Well, good afternoon. Good afternoon and welcome to another of our webinar Wednesdays. This is episode number 305. Good afternoon. I'm Kelly Bearden. I am the host and director of the Cal State Bakersfield Small Business Development Center. We're going to be talking about new law changes in 2024, things that you need to know from an HR perspective, and maybe even a little beyond the HR side of things today. So let's get going. So what is up today? Today, January 17th, 2024, our second webinar of the year. So we're going to be talking about some law and regulation changes in 2024 that could affect your businesses. So we'll bring in our HR consultant, our marketing, and our restaurant consultant, although she does do marketing for restaurants, Celeste Young-Ramos in just a little bit. But before we get there, well, let's talk about some of the other things that could be impacting your business. And one of those is the new recent decision by the IRS in order to offer amnesty for the employee retention credit. So many of you remember the employee retention credit, and the employee retention credit as being a great tool for business owners in 20 and 21 to receive a credit, a tax credit, in order to assist them in retaining their employees. So it really has kind of gone a little bit sideways since then, which is why we have an amnesty details coming up for you. And we'll get into a little bit about that. Also, one of the big things impacting a lot of business owners that are not sole proprietorships, as a matter of fact, almost all non-sole proprietorship businesses that are LLCs, that are S corporations, regular corporations, and other type of business entities, is the beneficial ownership information that will need to be filed as part of the CTA, the Corporate Transparency Act. So we're going to have a little bit more information on that, as we probably will until the due date of March the 31st for businesses that were in operation before 2024. Our capital quarter is going to make a quick debut in 2024. It's our weekly program that we usually, a little segment of our program that we bring in and talk about the capital availability and some of the reasons why it's maybe more difficult for some others to get capital. So we'll talk just quickly on that today, as we are pressed for a lot of time. Also, our community calendar, as we turn the page into 2024, put up those new calendars, new events coming up. Our economic corner will return next week, although if we have time, we might touch on one of the segments that is affecting the economy and tied to today's topic. We'll see. As always, we will answer your questions. Please, if you have questions, go to the Q&A box. Go to the Q&A box with any questions. We will take them following Celeste's presentation and before any other discussion that we have. So put them in the Q&A box. Maureen Busher-Deng, our Webinar Wednesday producer, will be manning the chat box, and she will be adding a lot of resources that we talk about today into the chat. And so you can just grab and go with those particular topics that are available. So those are going to be in the chat box. And today, no poll today, because instead I am going to do my annual reading of our little disclaimer at the bottom. And please note that this information changes often and is based on current understanding of all programs. It can and likely change. We encourage you to consult your legal reps, CPAs, financial advisors, and or your SBDC consultant. Opinions expressed do not necessarily reflect the CSUB SBDC or our partners' views. So there you have it, the legal aspects out of the way. So moving on, and one thing about that I really have talked about since 2020, and that is dealing with the employee retention credit and the fact that you should bring in your CPA, you should have your financial partners. Because why? Because the earned or the employee retention credit and the amnesty that is coming out about it now is kind of like you didn't consult, or some of those didn't consult their CPAs. So a little bit about, just real quickly, about the ERC. The retention credit, employee retention credit, was designed during COVID in order to assist businesses in keeping and retaining their people. After a while, it kind of transferred into a lot of people leaving and looking at new job opportunities and things like that. So great by design, because we figured that there would be a lot of issues going on. So the credit was up to $26,000 per employee. But the one thing about these credits is that any tax credit that businesses receive, especially those that are wage-based, have to reduce your wages on your tax return. So in 2020, if you applied for, say, the third quarter of the ERC and you had 2 employees and received $52,000 of tax credit, your wages for that year on your tax return needed to be reduced by that $52,000. So that is going to facilitate the filing of an amended return. And if you have a amended Schedule C, or you have a amended other return, and this is if it wasn't caught in that next, cycle by March 15th of 2021. So say you filed after March 15th of 2021, or you were able to take the credit throughout 2021, 22, or even up until 2023. So that would have facilitated a amended tax filing of your corporate income taxes. And that is really kind of the basis of the whole problem of why we're getting to this, is that a lot of people didn't understand that and didn't know that they needed to go back, file amended returns, or that if they even met the eligibility. So then the IRS comes out and they start with, a lot of audits, thousands of them, hundreds of criminal prosecutions. And in a way to try to alleviate the situation, the IRS came out and said, okay, we're going to offer amnesty. And amnesty is going to be available for those who applied for the credit, but either no longer think that they are eligible, or they might have done it under pretense, or they might have even been impacted by some of the marketing and some of the heavy marketing that was being done, and some of the advice that they took from marketing professionals rather than accounting professionals. So now we have the Employee Retention Credit Amnesty Program. And with that, you can actually pay back 80%. So you get to keep 20% of the credit. And, the IRS thinking on that was that, you only have to pay back 80% because a lot of people paid 20%, extraordinarily high amount for the credit, but thinking that they were getting 80% free money. I know I'm thinking the 80-20 rule is in effect again, and it sure enough is. So you have to pay back 80% of the credit, but you're kept with 20%. So if you actually did it yourself, or if you had somebody charge you an hourly rate to do it, you're going to come out ahead on that part of it, if you no longer think that you are entitled to that, or do not want to go through the amended return processes, which could be several years of amended returns and fees for that. And plus, you're going to be paying more tax. By reducing your wages, unless you didn't pay any tax at all, if you paid tax, then by reducing your wages by the amount of the credit you receive, implies that you're going to owe tax. And so if that goes back to 2020, that tax is going to be penalties, it's going to be interest. Now you're starting to see why there is an amnesty program that is actually being offered. So the IRS, as a bonus, if you take the amnesty, you have to notify them by March 22nd. You cannot be under criminal investigation or an employment tax audit already. You don't have to pay back any of the interest. The IRS is allowing employers to deduct the full wages from their income taxes. So you get the full wages, and by relinquishing their ERC claims, the IRS won't impose penalties or civil penalties on them. However, they are not providing amnesty from criminal prosecution if there was fraud involved. So that's a little bit about that. And a little bit about the amnesty program that is in effect until March the 22nd. Again, like we've said all along, consult your financial professional, your CPA. Tax season's rolling up. You have until March 22nd to figure that out. And so see if, most likely, if you consulted your tax professional, you're fine. Okay, so the other big issue that we're going to be talking about, and going to be doing this for this quarter also, the first quarter of 2024, is going to be the Corporate Transparency Act. And that's how we have been calling it. But the actual form itself and the actual information that you have to provide is called the business ownership information. And it's going to really heavily affect those that have 20 or fewer full-time employees. You know, if you're Pepsi-Cola, if you're Coca-Cola, the feds are going to realize that you are already a legitimate corporation or LLC. What they're looking at is the smaller ones that could affect a lot of the other entities and a lot of the other things that can go on with corporate ownership. So they will be collecting information in that database. We won't go to the database today. Last Wednesday we did. We went to the FinCEN database, and that is the financial crimes database where this will occur. Now, the one thing on that database that I think is incredibly important that you should realize is that there is not going to be any attempt by them to contact you for your personal information. There's scammers already working this, and it's in red ink on that particular website. The ownership filing, if you don't do it, will be subjected to very heavy fees and penalties for not doing so. But they will not be contacting you to supply ownership information, social security numbers, and the such. So this is something that is voluntarily going to have to be done by the business owner of an LLC, corporation, C corporation, S corporation, and potential others to try to limit illegal activities in money laundering, tax fraud, and other undesirable acts. So the filing affects those that generally own 20%. However, and I say however in capitals, many other conditions and requirements will apply on a case-by-case basis. In December, when we talked about nonprofits, we talked about how it could impact nonprofits. So the filing deadline is March 31st. This thing has been continuing to evolve. We will have a particular program dedicated to it coming up probably in February as we continue to get the word out for those that are in need in order to do this. Again, if you were in operation prior to 12/31/23, it is going to be March 31st, and it could even be sooner for those establishing new businesses in January, as we are now up to January 17th. Okay, so that's the Transparency Act. I'm going to go back a little bit here. I skipped a slide, and that is going to be just a status of our key local programs that are up and going. So of these key programs, we discussed that amnesty might be available for those that have the employee retention credit. If you took the employee retention credit, and you feel that you're comfortable with that and everything, like I think most of you are, then again, I would just make sure that you have filed amended tax returns in the past if they're applicable, and any other past filings that you need to do. For those that are waiting to see if they receive employee retention credit for 2021 and 2022, the program has been paused and is likely closed and is not going to probably make any other tax credits. So if you weren't in earlier, it's likely if you're waiting, you're probably out of luck. Some of the other key programs that are going on is we saw our 2023 December storm, SBA disaster, that we'll talk about maybe in the next month or so. It is open, and I haven't really heard of a lot of flood damage. I've heard of damage maybe on the coast in the Ventura area and other areas, but Kern is a disaster county. So if you did last month suffer some storm damage, There is some relief coming, and we will cover that in due time. If you had storm damage from 2023, the storms back in February and March, that is now closed. However, the City of Bakersfield Entrepreneurship Grant Program is open, along with the City of Bakersfield Safety and Security Program for changes to your brick and mortar location that provide a safer environment for employees, for employees, for customers, and for others visiting your business. And there's various lending programs that we will talk about in the ensuing months. So there's your status of what is open at this time. Moving on to our community calendar. You're invited to the State of the County, Kern County. The State of the County will be held at the Mechanics Bank Convention Center on actually January the 25th from 5 to 9 p.m. Feature incoming Board of Supervisors, Chairman David Couch, and other Kern County community and business leaders will be there for that banquet that evening. So for more information, you can contact the Kern EDC for a ticket. Our friends out in Ridgecrest, the Indian Wells Valley Economic Outlook Conference is coming up, a premier economic forecast event for the region. You can contact the Ridgecrest Chamber of Commerce. The event is coming up on February the 22nd, and always a great event for Eastern Kern County. Our Bakersfield Women's Business Conference will be coming up later this spring. And actually, they're going to have, again, their power pitch competition. As we promoted like last year, we promoted it to those that are, have an idea, an opportunity, that are looking to pitch their business or an idea to win money, monetary prizes that they can invest in their particular business. February 2nd is the last day to actually participate in that event. So that's coming up. And then also, when we had the Kern Community Foundation, Mr. Aaron Falk on last time, we didn't really talk about much, but they do have a grant program for the Upper Kern Fisheries. The UKF, everybody needs an acronym, so we might as well have a UKF. And, UK was good enough. But the grant-making initiative supports conservation projects for the Upper Kern River Basin. And so that deadline is coming up on January the 19th. Again, we're starting up and working with Nurture. And Nurture provides daycare business training for those that are wanting to get licensed to host and operate a daycare business out of their home. The 12-week course is starting soon. Grants are available, a $1,000 startup grant. We're trying to work with some also to get secure other monies. There are classes in both English and Spanish languages. You can talk to a Nurture coach at 916-919-1353. Really a huge problem. Kern County is a child care island. Need more resources, need people to operate in a professional and business manner and make money in doing so. And the Nurture class is doing just that. If you feel you need some other human resource consulting, and you maybe talk to our speaker, Celeste Young-Ramos is an SBDC consultant, but here throughout the Central California region, the San Joaquin Valley, the Central Coast, and the Eastern Sierra, a number of different resources that are available through the California Employer Association to provide assistance at no cost to the employer. There's a number for, in Kern County, Inyo and Mono. You will dial 888-201-5817. Other numbers are located there. Our SBDC has a variety of tools that can help you, particularly in growing your business. SBDCnet, sbdcnet.org, which is a national clearinghouse, fantastic information. You have to be an SBDC client to accept information or get information from that particular site. But there's a lot of other tools, such as Live Plan, our forecasting for cash flow, some of our cash flow tools that were presented about a month ago, a little over, by Cash Flow Mike Milan. So a lot of tools that are available to help you grow your business. Subscribe to our YouTube channel. Yes, you can get this webinar, notification of this webinar when it hits the YouTube channel at CSUB SBDC. Subscribe to that and you will get a notification a couple of days after the live event here on Wednesdays. So there's an opportunity there. Our capital, we were going to debut our capital quarter. Here are some of the factors that we came up with in the last 6 months that can limit your ability to raise capital. I'm not going to go through those right now because I want to bring in today's special guest. And our special guest today is Celeste Young-Ramos. She founded the Restaurant Success Center, a restaurant and human resources consulting firm providing food and other business owners and their managers the skill and support needed to grow their business. She advises with our CSU Bakersfield SBDC clients on restaurant and human resource issues. Industry and experience includes many years advising large franchise operations and also hundreds of independent mom and pop restaurants and food service operators of all kinds with over 20 years experience, both as a franchise director and in the human resource field for a large franchisee, multiple outlets of Denny's restaurants in Southern California. And she also has 3 decades in the food service and restaurant industry. Always a pleasure to have Celeste Young-Ramos on the show. Celeste, welcome and take it away.
Well, thank you. It's so exciting to see so many positive resources out there. And I'll have to say Happy New Year, everyone, even though Kelly says you can't say it after the 3rd. So, but it's the first time I'm seeing you guys this year, and I'm very excited about it. So, and I'm always excited about talking about one of my favorite topics. Whoops, my slides need to get back to the top. Sorry. So today we're going to talk about the 2024 California legal and HR updates, and there's quite a few this year. I have here restaurant edition, but it really is going to apply to every business out there, particularly minimum wage and things like that. So as we go through, if you have any questions, please put them down in the chat for me. I'll be glad to discuss those. So here I am, Restaurant and Human Resources Advisor. I'm based out of Los Angeles, but I do work throughout the whole entire state, and particularly here at the Bakersfield SBDC. So today we're going to talk about the new minimum wage laws. We're going to talk about how that's going to change the exempt employee salaries. I'll review the Wage Theft Act, which isn't really new, but I just hear so many people not being aware of it. We'll talk about changes to the California sick leave and bereavement leave policies, changes to the California food handlers cards, the new I-9, and also there was one that just recently came aboard, which is workplace violence training. So we have a lot on our HR plate today. So the first one we're going to start out with is talking about the minimum wage. This you guys should already know. It went into place on January 1st. So our new minimum wage is $16 per hour. And this is going to be regardless of whether you're a small employer or a large employer. And we're going to continue to possibly see wage increases each year. It's going to be based on the increase in inflation. So the inflation if it exceeds 7%, it will trigger us to have a universal minimum wage for every size business. And it's going to go up every year depending on whichever is greater, 3.25% inflation or the 7%. So those of you that may have businesses that extend outside of this area down into Los Angeles, the city of Los Angeles will announce theirs in February. There are some jurisdictions where they have a higher minimum wage than the state. You'll have to check your specific pocket and see if that applies to your specific city. And most of those will go in effect in July instead of January. So that is the minimum wage. And every time minimum wage goes up, if you have salaried exempt employees, these are like your supervisors who you work as many days and hours as you want. You're not doing overtime or having concerns about meal periods and breaks, and they don't keep a time card. They just get a flat amount of money every week. When minimum wage goes up, their wage is also going to go up. So here we have, it's got to be 2 times the state minimum wage. So they have to be making at least $32 per hour for a 40-hour work week. And so their minimum wage needs to be up to $66,560. So this minimum wage for the salaried exempt is just one aspect of being able to have them work with no, without recording breaks, or work overtime without having to pay them overtime. There's a couple other things as well. They have to be making hiring and firing decisions. They have to supervise at least 2 employees, and at least 51% of their day or more has to be done in managerial duties, like doing inventories or counting cash or counseling employees. So I find when I'm out in the field monitoring different businesses, that I find that they'll often tell me, oh, we have a head employee and we're, paying them salary exempt, and they're not meeting this number, and they're not having them supervise anybody. So you really need to look this over. And if you're confused about it, you can always make an appointment with me here at the SBDC. But misclassifying them as a salaried exempt when they aren't could be a penalty of $5,000 to $15,000 per violation. And if you got multiple people doing it, it's going to start adding up. All right. Now, all last year, we were following in the restaurant industry the Fast Food Recovery Act, AB 257, where they were trying to have minimum wage go up to $22 an hour, and to create a 10-person council that was going to really control all aspects of the labor laws, from working conditions to wages, etc. And that was the big thing. It was supposed to be on the ballot last year. There was some kind of snafu on their end of getting everything in they needed to get in to put it on the ballot. In the interim, Governor Newsom has negotiated with these labor unions that were pushing this, and they came to an agreement that the fast food restaurants that have 60 or more locations across the nation, those locations that are in the state of California will begin paying $20 per hour on April 1st of this year. And also a 9-person council that has only the power to set the wages in this industry can raise it. And this is where we're getting, into that 3.5% or annual change in the consumer price index. So, so I apologize for that error I made a little earlier. I got a little ahead of myself there. So this is actually, it's kind of a win. It's, it's like we've got $20 an hour compared to $22 an hour from before. We have a better council that's not going to be able to do all of the wide range of labor rules, from the temperature of the rooms that had to be set, et cetera, what I heard on the first version. So now it's just going with this minimum wage increase through the year 2029. So every year it'll rise a little bit. But also the other law was going to make it impossible for there to be franchise businesses in the state of California, because they were going to put all of the control, the franchisor be responsible for the sins of the franchisees. So this is a better alternative. $20 an hour is considered right at the borderline of a living wage in California. I think it's actually closer to $21 an hour. So they're trying just to get this industry closer to paying a living wage for their employees. Also in June, if you're in the healthcare industry, minimum wages will also increase. There's different ranges depending on what type of facility employs the person. So there's going to be a minimum wage of $18, $21, or $23. And I'll put a link in the chat for you with the information on this, because you really have to look at a chart and see where you fall into what type of facility that's employing you. So that will be raising the minimum wage there as well. So the fast food industry for the larger chains and the healthcare workers both received an even higher minimum wage here in 2024. Now, the one thing we all say is, oh my gosh, how is this going to affect me? And whenever minimum wage goes up, of course, we have to pass it along to our consumers. Now, I follow the restaurant industry because that is my specialty. I know I was seeing that McDonald's hasn't yet said how much they're going to increase their prices due to the $20 minimum wage. However, Chipotle has said they're going to raise their prices to the customers by at least 5%. 5% to up to 10%. They didn't give a specific, but it's going to be in that general range. And there was a Berkeley economist, thank you, that said when wages rise 10%, costs in the restaurant industry usually go up 2% to 3% to the consumer. So since we're going up quite a bit more than that, well, we should probably see close to that higher single-digit increase on prices to the guests. And we'll probably see the same thing happening in other non-fast food situations, because as people see they can get a higher wage over at a fast food restaurant, it may cause people in a regular restaurant to also want to do the same. Usually that's what we see every year when we have wages go up for the minimum wage. We often get what we call wage compression. So the people that are actually making a little bit more also then feel like they need to be getting a little bit more. And in the restaurant industry, that's usually the cooks. They always seem, from my 30 years of experience, they seem to want to always be making at least $3 or more than the minimum wage servers, so that where they feel good about it. So there's usually going to be definitely a compression in those wages that we're going to have to deal with. So, you know, I would just say put pen to paper and calculate the increase in the costs that's going to cost you each year in that wage, and you know, send those prices up to the consumer. I mean, as it is, we're already seeing it out there. It's getting pretty bad when 2 fast food combos at some of these restaurants are $30. I never thought I'd see the day, but we've gone through wage increases before, and we'll eventually be able to, you know, settle on a number and get more accustomed to it. Because one thing is we do want to see our employees have a living situation. All right, another thing that I wanted just to briefly mention is, you know, we really want to be up to date on our labor laws because of the Private Attorney General's Act, PAGA lawsuit. This is something that started, I think, in about 2013, where an employee, if they have a labor issue, they can get an attorney and then represent all the employees in the whole restaurant, or not even restaurants, it's any business that you're in. Okay. And the labor department, you know, was pro this law because they knew they didn't have enough people to really monitor some of the smaller companies. And so they tried to create some kind of avenue so that the smaller employees of smaller companies could represent themselves. It's not been very popular in the fact that it creates like a very simple class action suit. So they can complain about not getting their 10-minute breaks, not getting their meal periods correctly, and getting paid that premium wage that you're supposed to pay them if they don't get that, or any other lawsuit, like something, any other issue, like not getting everything on the paycheck properly, you know, the right categories and sick leave and things like that. And so they can go back and look at your company records for up to 3 years for every single employee. And every time they find a violation in a pay period, they're going to fine you. So like when we have someone not take a break and we're like, oh, you know, I'm not gonna give them their 1 hour wage to compensate that non-break premium. It could end up costing you several $100s instead if you fail to do it, because they'll charge you a fine for not complying. They'll charge you a fine for paying them late, and they'll charge you a fine for not having it accurate on the paycheck. So it really can expand. And that's why the average settlement on one of these private Attorney General Act lawsuits is nearly $1 million. And 75% of that is going to the state, and the rest is going to lawyers, and the employees are actually getting a very, very small fraction. So if you haven't had your HR policies and practices reviewed in a lengthy period of time, if ever, I would highly recommend that you put a little bit of money out and have an HR professional really look over your practices, because it'll be some of the best preventative maintenance money you've ever spent. And I've seen some people actually end up losing their restaurants because there were so many fines. And you know, this isn't like $1 million to the big gun chain restaurants. This is $1 million hitting small business entrepreneurs. So yeah, I don't know. Talking about it gives me a little bit of the willies, quite frankly. All right. I also wanted to bring up a law that actually came in effect last year, the Wage Theft Act, but I see a lot of people still violating it, and it makes me nervous that they could get themselves into some criminal liability. And with the wage theft law, it says intentional theft of wages of an amount over $950 for one employee, or an aggregate of $2,300 for a group of employees, is now considered grand theft in the California Penal Code, making it a felony instead of a misdemeanor. And where we will see this typically is where we're not meeting, a person's not being paid minimum wage. They're not being offered overtime. They're not getting paid for those meal breaks I talked about. Or people are charging their employees for credit card processing on the tips, or keeping tips. You know, I see that in the industry where some owners tell me that, well, they're kind of short on cash, so they just keep the employee tips. Well, that can be considered a felony. So you really need to look at all those practices where you may be withholding wages that are actually supposed to be given to the employees. Okay, because $2,300 if you have, you know, 6 or 7 or 25 employees is going to add up very quickly. And one thing that I see when I'm doing audits of businesses is that there is a document we're supposed to be giving to these employees so that wage theft can't happen, because they're notified of everything that they're eligible for. And that's called Notice to California Employee. You can Google that and this form will come up, and it'll have your business information on it. So all your contact information, it'll have their written wage on there and when payday is, who's your workers' compensation carrier in case you're failing to file a workers' compensation claim that they're trying to apply for. And also it has the sick leave policy on there. And so I find many employees, when I go to different places, have never heard of sick leave, and it's because we're not giving out this form. And so once again, this could be one of those labor violations where you get fined every single pay period that you that you aren't you haven't provided this notice, and that's for every single employee. Another kind of pro tip for you is that when you do have labor law issues, they usually fine you by how many pay periods you have. So if you are a company where you pay weekly, you have 52 opportunities to get a fine, whereas if you pay, twice a month, you cut that in half down to 26 times. So if you're starting out a new company, you may think about that it's pretty commonplace that people get paid every 2 weeks. But why there's so much focus on this is in the fast food industry, particularly, they had done some surveys, and 85% of fast food workers reported that they either were denied their sick leave pay, they didn't receive overtime, 27%. 53% said they never got their breaks, or they had their breaks interrupted. So there's a lot of opportunity, at least in the food industry, and I'm assuming that in other industries as well, we can see some similar types of results. Now, we do have a new California sick leave law that's gone in effect as of the 1st of this year. Prior to this, our California state sick leave law was 3 days or up to 24 hours, whichever is greater. And now it is increased to 40 hours or 5 days of paid sick leave. And this can be paid out in several ways. We have a bucket method where you give them all 40 hours at one time, like at the beginning of their employment. And then every 12 months after that, they get the bucket filled again. Or you can use an accrual method where at least 1 hour of sick leave is given for every 30 hours worked. And then what they don't use just rolls over into the next year, and they can reserve up to 80 hours now with this new policy. I personally like the accrual method the best, particularly if you have a lot of turnover, because employees aren't allowed with either program to take the time before 90 days. But if you have a lot of turnover in your industry, like in the restaurant industry, some people will be working part-times, some people will turn over, so they'll end up getting less paid sick leave if you use the accrual method. So the maximum cap, if you're using the accrual method, will now be 80 hours or 10 days of sick leave. And so when they hit that maximum, they can't accrue anymore until they use it. And you can put in your employee handbook or notice the employee in a written form that you will only allow 40 hours or 5 days to be used in a 12-month period. So you can kind of limit not having to pay huge amounts of this out in 1 year. All right. There's some new laws on marijuana testing, since we do in our state, we can use recreational marijuana. So now they're banning the use of hair and urine tests for marijuana because it was showing up, long history of it in the blood for a long time. So now they have changed that. You cannot ask job applicants about prior cannabis use unless you're in the industries of construction, and also companies or federal, federal's not really a company, but if they're going for a federal job that needs a background check because the federal government doesn't support marijuana use. So you can still do marijuana testing if you'd like, but there will be different types of tests. Also, last year, a new policy came in effect called bereavement leave. This year, they updated it to include pregnancy loss. So if someone has a miscarriage or something of that nature, it's going to fall under bereavement. And this is for employers of 5 employees or more. And it just gives them unpaid up to 5 days off to take care of the passing of a spouse, a child, a parent, a sibling, a grandparent, a grandchild, a domestic partner, or a parent-in-law. And they also have to be employed with you at least 30 days at the time if they want to take the leave, and they have to use it within 90 days of that death. The law says there are no limits for leave, so if they have multiple family members that pass, they should be granted that time. However, you do have the ability to ask them for proof. So you could ask for a death notice or, something in the paper showing it, and the relationship. So if you got that one employee who said their dad passed 3 times and, multiple times in a year, you can question that. Now, for the restaurants, the California food handler law has changed. Previously, as you know, if you have an employee, any worker in the food industry has to hold a California food handler's card or have a manager level card like a ServSafe or Prometric or something of that nature. Now they're saying that the employers have to pay for those cards, and also they have to pay for the time worked. So previously, the employers did neither one of those things. You just brought your card in, but now it's going to have to be compensated. And they also said necessary expenditures or losses associated with obtaining a food handler card, but weren't specific. The only thing I could think of is perhaps that they signed up for one of the courses where they didn't let you have unlimited retests and they had to pay another fee to take the test again. Otherwise, there really shouldn't be anything else. The law says the class can take up to 2.5 hours. So you might want to look and source a company that has training that is under an hour, like under an hour, 2 hours. Like I know at Restaurant Success Center, we have one that's an hour and a half. So right there, you could save 30% off that training just by the time change. So not the people that already have their cards, you don't have to retrain them, but anybody new that doesn't have one or expires, you're going to have to put this into your labor budget. So that is going to increase costs a bit more. So the class by law has to be less than $15. It has to have a course and an exam done within 2.5 hours and have 40 food safety questions. They also have to have a score of 70% to pass. Now, I did see when I read the ruling that it's talked about in-house training, but it didn't clarify that. I'm sure everybody would want to try to get into in-house training if available, but I read it all over. I investigated. I couldn't figure out what they were meaning by it. So if I get any further information, I'll pass it along to you. There are some carve-outs, certain businesses where they'll still require the food handler's card, but it won't be the responsibility for the training and the purchase of the card. And that's if you're operating in a certified farmer's market, at a commissary, a grocery store, a convenience store, licensed healthcare facilities, mobile support units, not meaning food trucks, public and private school cafeterias, restricted food service facilities like prisons, things like that, and in some instances, retail stores. So there are some groups that do have a carve out for that. And another thing is another law came into place for more training. And this is called the Mandatory Workplace Violence Prevention and Injury and Illness Program. So this is part of OSHA. If you have 10 or more employees already, you're required to have an injury and illness prevention program. It's called an IIPP, which if you talk to your workers' compensation company, they may have samples of IPP programs that you can use. They have just added this now mandatory requirement for workplace violence. And this is going to have to be done by any company that has at least 10 employees. But there are some exceptions. So if you have remote employees, like they're working from their home and things like that, they're not coming in contact with customers, they don't have to have the training provided. If the companies have fewer than 10 employees and they have no business access, so perhaps you're a manufacturing company and everybody's just in the back and they don't come in contact with customers, then you don't have to provide the training. The training is going to be just educating them on what to do if there is a workplace issue. It also talks about that a company can get a restraining order against someone that comes in that has violence or has shown violence. Even if the employee that it's directed at doesn't want to have the restraining order, they can not be listed on it, but the employer can still follow through with, getting a restraining order against that violent person. And it also requires you to record and keep a log of any time you had a violence issue in the business. And, depending on some of your industries, that might not be very frequent. I know from my experience in the restaurant industry, at least in 24 hours, after 11 o'clock, sometimes customers could be quite different than the morning customers. So sometimes we see maybe an increase in things that we need to teach our employees to be aware and what practices to take place. So I will put a link in the chat so that you can look into this a little bit more. I noticed that the OSHA website had some resources available already for like the health industry and also for the restaurant industry with some training materials that could be used. But you might want to reach out to your workers' compensation carriers as well and see if they have any tools that they could provide for you at a minimal cost. There's been some changes in arbitration agreements. So there have been some back and forth over whether employers can require mandatory arbitration as a condition of employment. And after a 3-year battle, they say you can. However, employees may not be required to waive any right, form, or procedure for a violation of the Family Employment and Housing Act or the California Labor Code. And also, federally, employers cannot compel arbitration for sexual harassment or sexual assault claims. I did hear there were some changes also regarding having it where you could say employees couldn't enter into class action, but I'm not a legal advisor, so I would always recommend that you contact a legal advisor if you'd like to have arbitration agreements in your business. Yeah, I think I only got one more thing probably. Yes, we have a new I-9 form. We are way overdue. The last one expired in 2022. And now we have a new I-9 form with an expiration date of July 31st, 2026. And you will be able to get that on the website. Just Google IRS revised I-9 form. It now is a 4-page form with page 1 including the employee section and the manager ID verification. And then the second page is the list of acceptable documentations. They now have a full page for translator affidavit and then a full page for re-verification and rehiring. So you'll want to check that out for any people that you're hiring from now forward to make sure that you're using this proper form, or that could be a violation if you ever get audited. So with all things, when we are updating minimum wages, you definitely want to go in and get updated state labor law posters because we've had quite a few changes this year. All right. And here's my contact information. If you are an SBDC client here at Cal State Bakersfield, you can also talk to me through that system. But if you're not, you can contact me directly and I'll put this information in the chat. So I took up all the time, Kelly.
No, you didn't. You just think
So
you did. We have
I,
time for questions, and we're going to
okay,
hit the question Q&A. Let me read you a few questions real quick.
please.
We'll hit the chat. There's a couple of interesting things in the chat I want to discuss. So um, the first question is, how about 100% ownership? And I think that's going back to the CTA.
Hmm.
100% ownership, definitely. So it's anything over 20%. And in some limited cases, even less than 20% will require you to file the business information form. So next question, another on this CTA. No full-time employees. If you're an LLC, yes, you're still going to require to file that, even if you have other jobs and other business interest. If you're a limited liability company, a corporation, C or S, or other entities, and you own 20% or more, and in limited cases, even less than that can actually apply. It's complicated, so we will get back with that, but yes, on both of those. Okay, one for you.
Oh,
Two for me,
good.
one for you. I don't like that
Hope
ratio.
there'll be one I can answer.
We work at two local farmers markets and have two individuals that we pay cash. Maximum hours, $10 for the weekend. We're being told we need workers' comp to continue at the market. Take it away.
Yeah, yeah. So if you have people that are actually doing the function of what your market is like selling and things, usually they're going to fall under being in the employee category. You'd have to look, at what we call the AB5 test. And if you have a lot of control over them, like you're telling them what they're going to get paid, when they're going to work, what they're going to wear, how they're going to do things, then they're definitely employees. And so that would then require you to get workers' comp and everything else. But if you'd like to set up an appointment with me here at the center, I'd be glad to look at your situation in its specific nature. Nowadays in California, it's very hard to have independent contractors like we used to. And just because you know someone that does something in their company that way doesn't always mean it's correct. So it's always better to check it out because it is a $25,000 misclassification fine, and you have to back pay wages and things too. So, or pay payroll taxes and things like that. Good question.
What
Any other
is
one?
what is the expiration date of the California Food Handler card?
It's a 3-year expiration from the last time they took it.
Years. Okay.
So they rolled it out in like 2017, I think it was. So it's like a large portion of workers in California will have to do it on every 3-year increments, So 2023 was one of the really big years that a whole bunch took it. So you'll have kind of those people that entered in after those time periods. But you'll have to kind of keep a little monitoring system like you probably already do to make sure that everybody has it.
Okay, going to the chat. Tremendous resources put in by Maureen, and basically the ones we talked about, they're all there, and you will get a follow-up email with all those resources and also a recording of today's presentation. Um, I got two question type things. The first one is for the medical minimum wage, it says medical heavy hospitals will start at $18 per hour, I assume. Does that mean that Medi-Cal heavy clinics are the same or only hospitals? Got a tough one for you.
I'm not really sure on that myself. I'm only kind of glanced over that. I did put the link in the chat so that you can go and do it more because it's very specific, and I didn't understand some of the terms on the different levels of the types of facility. So I would refer you to the link with the article about it,
Okay.
or talk to your, like, if you are part of a association for medical industry, that would be another good source.
Okay, great. The next one is a question, is more of a comment, but I really wanted to discuss this, and I'm glad Andrea asked. And it's what happens when our customers continue no longer want to pay higher prices. Yes, it's very expensive here in California. I'm all for paying employees more, but now that we've raised our prices to accommodate living wages, we're losing business, we're losing customers, we're losing insights from other business owners. How about some insight from other business owners in the SBDC in regards to dealing with the loss of customer visitation in regards to higher prices? I am glad you brought that up because just in case I had just a little bit of time, I did want to bring this up and have maybe a discussion on what the $20 million minimum wage. Celeste talked about what it's going to happen with compression, but it's impacting all mom and pop and smaller independent businesses. And when I talk about mom and pop, I mean smaller locally owned businesses. So we know that the $20 is coming and it is affecting mom and pop and they're under siege. So in dealing with that, I think that there maybe is an opportunity for future webinar topics that we have on this area. We could talk about strategizing for retaining employees with a $20 minimum rate, because that's going to be one of your first crises that's going to be coming in March or April. And that is going to be, a lot of people won't be giving up those minimum wages at fast food establishments, but
Yeah.
There will be an issue with trying to retain employees that could be leaving $17 an hour wages in a restaurant to go to work at a fast food joint for 20 bucks. So that's one thing. But also, what are some of the solutions that we can talk about beyond technology for high labor states that mom and pop businesses reside in? And my point behind that is what you see in California is you see fast food establishments might be paying $20 an hour. But the other part of that equation is their food costs are substantially cheaper than independent businesses. And that is because many of them, or most franchise fast food restaurants, they produce and do their food prep out of state in low minimum wage states in factories and then have it shipped to California. And so their food costs can be dramatically less. So what are some of the solutions for high labor states beyond technology that we can talk about? So,
Well, and they can also buy it at large volumes and get discounted rates that the small business owner can't touch, you
so
know.
I think that's a discussion that I think that we need to have and in preparation for the higher minimum wage that's coming. And so thank you for bringing that up. And so we will be uh, actually going that direction and trying to do more in that area. And please, in your survey this week or another time, put in there what you want to see regarding these issues. And we will bring these topics to you and bring up. I think the perfect topic for that is have 3 restaurant or food type businesses and talk about what their retention strategies are going to be and what are some of the solutions that more small businesses can take in dealing with this potential crisis.
There was one more HR question about sick leave. I don't want to leave before I answer Ava's question. It says, if you record the 40 hours at the beginning of the year, must you do a year-to-year accrual? No, you don't. Just if you're doing the accrual method.
Okay, well, there's another question then.
Yeah.
So the new law will affect employers that receive the government help for COVID, and that was a question.
What was that for?
New law will affect employers that receive the government help for COVID.
I don't know.
I don't know if
I don't
that's if
understand that.
that's tied to the employee retention credit. So I just think just a little bit more information is needed to answer that potential question. And we're going to give you just a couple of moments because we are out of time. We're along.
Yeah, I thought you were going to have me try to solve that whole minimum wage industry thing in 5 minutes. I was like, holy cow.
I think
That's definitely a whole webinar.
that's at least the whole webinar and
Yeah.
probably beyond, but it is a crisis brewing. So, well, that's going to wrap it up for today. Celeste, always a pleasure having you on.
Bye,
Always a
everybody.
pleasure, and thank you for all the fine work you do for our businesses in Kern County and beyond. So thank you. And we'll be back next week, webinar number 306 next Wednesday. So Celeste, any final comment?
No, I would just say kind of look over these things I went through and see how you have them applied in your business. And if you need any assistance, you can always contact me and I'll be glad to help clarify it for you.
Yes, and hopefully, our state legislators, they can take a vacation. They don't have to write so
Yeah,
many
they were
laws,
busy. I think they did 2,500 new
Just like,
regulations this year. I don't
it's
know how
not
they have time
quantity,
to
it's
read them all.
quality. It's quality, not quantity.
Yeah. Well, I'm
Okay,
going to see you
Celeste.
later. I have somebody waiting for me. So bye, everybody.
See you next week. Bye-bye.